Hi, I'm Jane Dearwester with McIntyre Elder Law, and I'm going to talk to you today about guardianships. This is something that we deal with quite a bit in our practice. We do estate planning and elder law. So first, I want to mention one way to avoid having to do a guardianship is to make sure you have appropriate powers of attorney in place. So there are two powers of attorney that we recommend for everyone to have: a general durable power of attorney that allows your agent to act on your behalf with financial and other legal matters. And then there's the healthcare power of attorney, which, just as its name implies, is a document that allows your agent to act on your behalf for all healthcare decisions. If you or your loved ones do not have those powers of attorney in place and the person is losing capacity, what you have to do then is seek legal guardianship from the courts to have your loved one declared legally incompetent, and then have the appropriate person appointed as a guardian over that person to protect them and to handle their legal and medical affairs. If it's an emergency situation, we can file what's an emergency petition. It's called an interim petition for guardianship, that we need immediate action. This person is either in a life-threatening situation, or something we hear very often for someone experiencing cognitive decline. They're experiencing confusion. They will leave and put themselves in danger or get lost. They'll drive around, they don't know where they are, or there are just a lot of dangerous situations that can happen when folks are losing capacity, cognitive capacity. So we can do this emergency guardianship, get an emergency guardian in place. If it's not an emergency, but it still needs to be done, we still go through a process where we file a petition. Those petitions are heard before the clerk of superior court. The court will always appoint what's called a guardian ad litem. This is just an extra layer of protection for the ward. The ward is the person we're seeking guardianship over, the person we're trying to help. So not only is our client, the person seeking guardianship, there to help, but the guardian ad litem is appointed by the court to be an impartial person who truly is there to focus on the ward, to the person we're seeking capacity over. It's a very serious proceeding. When someone is declared legally incompetent, they do lose a certain amount of rights, which nobody takes lightly in these proceedings. And so we really do have to show that this is in the best interest of the ward for them to have someone else handling all of their legal, financial, and medical affairs. We go through that process. If it's successful, a guardian can be appointed. That guardian can be appointed either as a general guardian, meaning they can handle anything for the ward, or it can be a guardian of the estate only, which means they're only handling their financial affairs, or it can be a guardian of the person only, which is more likely they're just able to handle their physical and medical affairs. And the clerks are going to be very discerning. They're going to only grant the more limited version. So if they don't think the person needs a general guardian over all of their affairs, they're really going to limit that to either guardian of the person or guardian of the estate. And so there's a lot to consider when you're thinking about guardianships. So if you have a loved one who's losing capacity and you need some help and they need some help, please come in, make a appointment for a consultation. We're offering free consultations to anyone who's watching this video today. You can go to our website and schedule a consultation at our Hendersonville, Shelby, or Charlotte offices. You can find us at www.mcelderlaw.com/scheduling. We look forward to seeing you soon.